USA versus Dustin Jacob Mcphetridge.
Please note that we have made every attempt to reproduce the transcript as it actually is. You may notice some sections sound like we have forgotten our lines, or we are stumbling on our words. The transcript itself reads this way. For example, yes, and again, there were times, again, I do not dispute that there were times when he may have risen to the occasion on a particular date, but the problem was the return to that status quo. With that out of the way, I hope you enjoy this look into the courtroom proceedings.
Anything else?
Your Honor, Steve Duncan.
All right.
And can you please state your name for the record?
Steve Duncan.
Mr. Duncan, if you could, just very briefly go through some of your background so the court knows, I guess, your profession and your educational background.
Okay. For the purpose of today, I've been called as a polygraph examiner, so my polygraph background started in 1994 when I attended the Department of Defense Polygraph Institute at Fort McClellan, Alabama. Successfully completed that training first in my class, and have been doing polygraphs, conducting polygraph examinations since then. I was the polygraph examiner for the Georgia Department of Public Safety and actually supervised that program in 2014 when I retired from the state patrol. Been teaching polygraphs since the late 90s, and I still actively teach polygraph examinations all over the world for several different private entities and teach regularly for the American International Institute of Polygraph in Atlanta. As far as number of polygraphs, I quit counting in 2000 that I've conducted several years ago, so I don't know exactly how many I've conducted, but extensive number of polygraphs. Kept up on continuing education training since I initially was certified in polygraph in 94 and had the post-conviction sex offender test training and so forth among the education that I've had as far as continuing education credit since then. Still conduct polygraph examinations, do by between 200 and 300 exams a year in employment testing, specific issue testing, and so forth.
And I'm going to streamline this a little bit because the judge had asked a question about whether we had testimony to suggest that the polygraphs were done improperly or incorrectly. Do you have any, the challenge to any of the polygraphs themselves? Have you reviewed the...
I asked that question before Mr. Taylor indicated that the government would dismiss number 4.
Well, then, if there is a full dismissal, then I guess this is irrelevant. Then, Your Honor, there's just a medical explanation for...
Is there a medical explanation for his lack of cooperativeness with...
No,
That's the real issue.
So, if we're not addressing the polygraph issue, then... Mr. Duncan, he's been here because I requested him to be here to address the failed polygraph because that is one of the violations. And, I needed him here for that purpose. But if it's dismissed, Your Honor, I don't want to belabor the point at all.
All right. Thank you, Mr. Duncan. You may be excused.
Thank you, Your Honor.
Anything else?
Your Honor, if you would like to look at the medical records there, it does demonstrate that he did have a fall in 2017, that he had a lesion separate and apart from the one that was at birth, the cerebral palsy. That was noted and detected only after the MRIS had been conducted most recently. And whether that explains anything from 2017 going forward, Your Honor, I'm not a doctor, so
What was the injury?
He fell on a table, Your Honor, passed out. And he was, he had to go to the emergency room.
Not a head injury, not a concussion now.
Well, yes, that was the issue, Your Honor. He had a lesion on the left frontal lobe.
And there's something in the medical record that states that impaired his ability somehow in some way.
Your Honor, I don't have a doctor to say that, no. I just can tell you that it can impact memory, cognition, etc. but I don't have a doctor to say all those things. I do, have all of his medical records. He did not realize until after the polygraphs had taken place, and, the things that this happened in April of 2019 going forward, he's learning more regarding his medical issues, and they're keeping a watch on those areas.
Hasn't he offered, though, an explanation for why those responses on that polygraph were thought to be untruthful? That is that he was fantasizing? I mean, why?
Yes.
You want me to find that there's some other reason now for him?
No, I'm saying, Your Honor, that, there's more than one explanation for that. It's a treatment issue. So if it's dismissed, then I won't go any further into that. But I will let Your Honor know that, he has had some medical issues from that fall 2017 going forward, to include added seizures, headaches, and, dizziness and memory loss. And so those things, Your Honor, it can impact the polygraph. If that is one of the petition allegations that is being dismissed, then it would not be relevant to that. But if Your Honor would like to consider that relative to the remaining, but regardless, custody is not the answer. Whether you revoke him or not, custody is not the answer in this situation. That's all I have.
All right, Mr. Taylor. Is it your intent to dismiss 1 and 4, or 1 and 3 and 4?
I'm going to need to look back.
2 and 3 are related.
If 2 and 3 are related, we'll just proceed on number 2, Your Honor. That keeps it very clean.
All right.
And simple.
All right. Do you want to make any further argument?
No, Your Honor.
All right. There has been a petition seeking revocation of Mr. Mcphetridge's term of supervised release in this case. That petition alleges 4 violations. The United States has already moved, and the court grants the motion to dismiss violations 1, 3, and 4. That leaves violation number 2, which alleges a violation of the additional condition number 14, which requires the defendant to participate in a sex offender counseling program approved by the United States Probation Office and abide by the policies of the program. In deciding supervised release revocation matters, this court applies a different standard than the one applied in a criminal case. In a criminal case, the government has the burden of proving the defendant guilty beyond a reasonable doubt. Here, in this supervised release revocation matter, the burden is on the government to prove the violation and what's called a preponderance of the evidence, which simply means that it's more likely than not that Mr. Mcphetridge violated the terms and conditions of his supervision. The undisputed proof in the case is that Mr. Mcphetridge was terminated from the sex offender treatment program in which he was participating in early 2019 based on a determination by the treatment team that he was not participating in the treatment program in good faith, that he was not putting forth his maximum effort, that he was instead minimizing and distorting the facts, and that he was somewhat dismissive of the treatment program, and that at times he attempted to shift the blame not for the underlying offense but for his performance in the treatment program. Now, I've been provided treatment records, and I will say for the record that I have not studied these records. They were only provided to me today, but I did take Miss Pierce's invitation to skim these records while Mr. Sexton was testifying. Miss Pierce is correct that there are some portions of the records that are favorable to Mr. Mcphetridge on the question of whether or not he has fully participated in the treatment program. On the other hand, there's information in these records that suggests that that was the kind of an on-again, off-again type of participation. But the clear and undisputed evidence is that after Mr. Sexton took over the supervision of Mr. Mcphetridge's treatment in March of 2018, I believe it was that he did not make progress in the program, that I don't remember the word Mr. Sexton used, but basically relapsed into his prior behaviors, did not fully cooperate, did not willingly participate, was not forthcoming, and for that reason has ultimately dismissed from the program. I find that the government has established, by a preponderance of evidence that Mr. Mcphetridge has not completed the sex offender treatment program approved by the United States Probation Office, and he was discharged from that program by the reason of his own behavior. So essentially, I find that he is guilty of violation number 2. Now, it appears that is a grade C violation, resulting in an advisory guideline range of 3 to 9 months of imprisonment with a statutory maximum term of imprisonment here of 36 months. The United States does not ask the court today to impose any jail time, and indeed, Mr. Sexton has testified that based on the documents written by Mr. Mcphetridge, he has indicated a willingness to be open and forthcoming in this treatment program, and is willing to accept him back into the program for a probationary period of, I believe, he said 90 days. So, Mr. Mcphetridge, I'm going to defer the imposition of any sentence in this case, allow you to re-enter the treatment program, as Mr. Sexton has indicated is possible, and reassess your progress in about 90 days. Now, I heard from Miss Rapier indicate that you had come completely clean with her. I don't know how far that extends to the rest of the congregation of that church, but you have committed here an underlying sex offense that is very serious, that involved the solicitation of a person you thought to be a minor 13 years old to engage in sexual conduct. I fully agree with what Miss Rapier says, that you should have an opportunity to go to church, but that interest has to be balanced against other potential victims, minor children. You can, of course, work with the probation officer to put a plan in place to allow you to go to church or other kinds of social activities. It looks like you were in the process of trying to do some of that, but there are legitimate concerns about the safety of the public, and in particular, the safety and well-being of minor children that cannot be overlooked. I don't think there's anybody here that wants to be punitive about this, but the offense was serious. The sex offender treatment is absolutely necessary, and minor children's safety has to be ensured. Indeed, that's the whole purpose of the sex offender treatment program, to provide you with the necessary counseling and treatment to try to ensure that this never happens again. You have to cooperate with that. You can't substitute your own opinion of what's appropriate treatment for that of a qualified treatment provider. You can't substitute your lawyer's thinking about what's appropriate for that of a treatment provider, and the court is not going to impose its own thoughts about that. Mr. Mcphetridge, it's been my experience over the years that quite often a lawyer's presentation in court reflects the client's attitude about various issues. What I've seen here today does not give me a great deal of confidence that you will not continue to distort or minimize or dismiss your situation or demands requirement of this treatment program. Now, you've written 2 very compelling documents here that indicate that you have issues that you want to have addressed, that you need to learn some social skills, that you need to control certain urges to look at pornography and things of that sort. And you have indicated in these documents are exhibits 2, 1 and 2, that you appreciate the help that people want to give you, that you want to change your ways of thinking. And what we're doing today is giving you an opportunity to do that. But please understand, and I want your family and others who want to help you and are to be congratulated for wanting to help you and have very good intentions when it comes to you, to understand that you've got work to do. You may be a far different person than Miss Rapier met a year ago, but you have not progressed in treatment. Although you began treatment in August 2015, you're still at step 1. That's the reason, Mr. Mcphetridge, that I'm going to defer a final decision for about 90 days. You'll go back to the treatment program, but you need to show Mr. Sexton and the others that you are invested in the program and that you're willing to put forward the effort that's required. I certainly take that into consideration when we come back. Now, I am here. You gave me a date of June 16th. Am I here? Isn't that the 6th Circuit Conference?
No, Your Honor. It's the next week.
The next week? Well, all right. If you all want to come back on June 16th at 1:30?
15th?
It says 16th. Is it the 15th?
It's the 15th.
All right. June 15th at 1:30. Then we'll see what kind of progress has been made. And I'll take appropriate action at that time. I don't think it's necessary for Mr. Sexton to come back. I think what I need is simply a report, Mr. Welch, from you about what the situation is at that time. All right. So thank you all very much. That will be the order of the court.
Okay, there's one other matter. I know the probation office cannot release property that they have taken during the searches that have happened. They have taken different items and everything, and I don't know when Your Honor wants to take those up.
Whenever you file a motion for return of the property.
Very well. Thank you.
All right. Thank you all very much.